Good morning.
Good morning, everybody. It is Monday, March 30th. This is exactly the way you want to start your work week. We are WGL AM. We are awaiting a Supreme Court orders list, joined as always by my two lovely guests, Miss Hannah Hill from the National Association for Gun Rights. Good morning, Hannah.
Morning, Bill.
And, of course, Kostas Moros from the Second Amendment Foundation. Good morning, Kostas.
Good morning, Bill.
All right, so just to get you guys up to speed, we had a conference on Friday again. We are carefully watching 5 cases. Duncan v. Bonta, probably the one we've been most carefully watching, challenged magazine ban out of California. There's another challenge to a magazine ban out of the state of Washington, Gators Customs Guns versus state of Washington, keeping our eyes on that. And then we got 3 assault weapon ban cases that we have been carefully watching for weeks now. NAGR v. Lamont, challenge to Connecticut's assault weapon ban. Grant v. Higgins, also a challenge to Connecticut's assault weapon ban. And Viramontes v. County, a challenge to County, Illinois' assault weapon ban coming out of the 7th Circuit. We have been in a perpetual kick the can down the road mode now for weeks on end. Hannah, do you got any predictions this morning?
Well, I'm guessing another kicking the can down the road simply because of the Benson case, and that's a mag ban case, and they also have the Duncan case. I think the Supreme Court is going to be a little hesitant about dismissing Duncan. So I'm hoping that translates into doing nothing instead of a denial, and I think that's what we'd be looking at this point.
Right. All right, Kostas, do you think that this Benson case has thrown a little bit of a monkey wrench into the process, or do you think who knows? What do you think?
I would hope so. I'm just not convinced, and I think the court will wait until the en banc has happened to see if there's actually a split there, or rather a decision on the en banc. Hopefully they don't en banc it, but we know what's more likely, unfortunately. That said, I'm predicting a per curiam today that decides everything, because nobody's going to remember if I'm wrong, but everyone will know.
Remember if you're right, and we will memorialize this forever on the internet. That
it's not going to happen.
Called a per curiam in Duncan. That would be incredible. Well, in the event that we do end up with a nothing burger, guys, one of the things I do, because I do prepare for the nothing burgers, you see on my script here, I actually have a line that goes right through it. This is everything above the line is, hey, if we actually get an acceptance or a denial, we're going to end up talking about that. And then if we get a nothing burger, everything below the line is what we'll get to talk about. Anna's got a meeting, I guess, to get to sometime this morning. I actually have to go throw a suit and tie on and go play lawyer later this morning, too, on a competency issue.
Which I'm not.
Well, yeah, it's if they would have charged my guy maybe a couple of years ago when the crime occurred, his brain may have been functioning a little bit better. But unfortunately, he's deep into the depths of dementia, and he can't even remember who I am each and every time we meet. So it's really a sad situation. So we are waiting for the orders list to come out. It comes out about 9:30 on the East Coast. And do we have any updates yet, guys?
There it is. It
is.
All right, here we go. We're going to do a word search, and right away, Hannah and Kostas start banging away on word searches for us. No Lamont.
No Duncan.
No Duncan. Here we go.
More nothing.
So
no Gators.
No Gators.
No Grant. No Vermont.
Grant's the most annoying one to search for.
Yeah. That's true. So you search it out under Higgins.
I'm starting to wonder if maybe we should start screening for names when it comes to plaintiffs.
Yeah.
So right now we are not getting.
Yeah, if it were Konstantinos versus Bonta, we find it
that would be a really good one. That would be
a fantastic one. As long as
it's a boxing match, not a case.
Yeah.
As long as the precedent was a good one, you wouldn't want your name.
You don't want your name. You don't want your name kicking around.
I've been joking how in 50 years, law students are going to be so annoyed with Rahimi and Hamani because they sound so similar. and they're both about like prohibited persons cases. And like, it's so that's
well, you got to get this. That's why you always pull for the good cape, the good names, you know, like that Mississippi Rod and Gun Club. Would be great. Haters Customs Guns would be a great name for a case to kick around in you know, the annals of history forever. All right.
I was thinking about the Bruin name, actually. The Bruin is what we always used to refer to it because it's easier to say than New York State Rifle and Pistol Association. But that's the New York Attorney General, and I know he hates that precedent. So.
Yeah, well, and it does go contrary to how it normally works, right? But I remember a content creator, Mark Smith, who the first couple of videos he did afterwards, he was trying to start the trend of just taking the abbreviation and calling it NSERPA, according to the NSERPA case. And I was watching the video. I like Mark. You know, Mark's a great dude, good legal mind. And I'm watching. I'm just like, oh man, I'm not calling it NSERPA. I'm calling it Bruin. I'm not going to do that. I have one. I want you guys to do a quick word search on. It's beard, but let me spell it. It's BEAIRD.
nothing.
Okay, that's one we're going to talk about here in a little bit because obviously I come to here with two scripts. Plan A, something cool happens. Plan B, nothing happens. So we move on to what we're now going to call the morning scramble, where we're just going to talk about a few other things before everyone gets their work week rolling. And the first one I want to talk to you guys about is Schoenthal v. Raoul, which is a challenge to Illinois' sensitive place, particularly public transportation. Now, that was supposedly distributed for conference on March 20th, but rescheduled. Then it was relisted for March 27th, but rescheduled. Now, we think that this is probably kicking around, waiting for a GVR after Lopez. Do you both agree on that?
Probably.
Kostas?
Well,
Maybe it's early in the morning. Which one's Lopez?
Sensitive place, vampire rule out of
Wolford. Yeah.
Lopez.
Yeah. I don't know, man, because I thought that when they rescheduled it last time, and then they put it back on the schedule, and then they rescheduled it again. So, like, if it were just about Wolford, why would they do that twice? You know?
Yeah.
I'm not. Maybe we're overreading into what the clerks are doing.
Is it possible that it just got misdocketed and somebody went, oh, wait, we weren't supposed to reschedule that, and then pulled it back out? I mean, is that a possibility?
I guess we'll know soon enough if it gets scheduled for a conference a third time. But then who knows? Maybe they'll reschedule it and pull it off. There's some clerk messing with us that watches this show probably.
Well, we do agree, though, that when Wolford v. Lopez comes out, it could have some application to the Schoenthal case. Do we agree?
Conceivably,
Yes.
But it depends how. So Wolford technically isn't a sensitive places case, even though it's about where we carry. It's a vampire rule, and like so the vampire rule isn't really a sensitive place rule.
Right.
So it depends how expansive they go. If they're holding Schoenthal for Wolford, that's a very good sign because that means they're going to say stuff about the greater question of where you can carry. If they're not holding Schoenthal, that's a bad sign because it means no, we're going to keep this very narrow and just rule on the vampire rule only and say nothing else. You know,
I guess it is an indicator, isn't it, of exactly where the court's going to go? Because there's a number of different directions they could go when they give the Wolford ruling.
right?
So that's
Yeah, I'm worried they're going to keep it very narrow in Wolford, but because I think for sure everyone agrees we're going to win Wolford, but the question is how. Like, is it going to be expansive or is it just going to be very, very limited to the vampire rule? Yeah.
Well, and the problem is if it turns out to be a limited opinion, which, by the way, would be where the smart money would be.
Yes.
The application of that ruling will not be as broad as we want it to be. And now we've had the Supreme Court waste a lot of bandwidth and time to take a 2A case that doesn't have that broad effect that we want from the highest court in the land.
Mm-hmm.
All right. Here's another one. We're going to have to start tracking this one. I'm assuming it's called Beard versus the United States. It's a 922 G1 case. So you're just like, there's been a million of them to come and go. But this one has had 5 conferences already. All right, which is a little weird. Now, when you take a look at issues number 1 and 3, you'll see that those are straight, 18 United States Code 922 G1, whether it comports with the Second Amendment, and whether 922 G permits conviction for the possession of any firearm that has ever crossed state lines at any time in the indefinite past, and if so, if it is facially unconstitutional, kind of a commerce challenge clause. And then in the middle of it, there is this second issue that has to do with commentaries on the federal sentencing guidelines. So I don't know if it's that middle issue that has to do with more of the federal sentencing guidelines that's kind of keeping that one ricocheting around the court. But, you know, what we've seen with these 922 G1 cases is they get on, they have a conference or two, and then boom, they all hit the chopping block. And this one's had 5 conferences. So I don't know if either of you have looked into it or if either of you have a theory on it. I have not had a chance to dive into the facts, but the facts are oftentimes pretty interchangeable on a lot of these 922 G1 cases.
Is it sad that that middle issue that has nothing to do with the Second Amendment is actually the strongest grounds for the Supreme Court to take it, from what we can tell?
That's probably the
It's
case.
probably a comment on the Supreme Court. Yes, you're right, Hannah.
No, I think that's exactly right. That's probably what's happening here. I'll look into the case, though, after this and
How do you
see.
spell it
Yeah,
again?
I'm gonna spend some more time on it to see if there's some interesting rub. You know, there was a good article in Ammo Land this past week that was a little critical of Chief Justice Roberts and about how he has, in the opinion of the author of the article, had been really working overtime to keep big Second Amendment cases from getting before the court. I don't know how much truth there is to it, but there was some fair criticism of it.
We know about Chief Justice Roberts, though. He tends to dole out the controversy on, he tries to ration it out. And, you know, I found a recent article, and I'm trying to look it up here, that kind of went over just the number of major cases that they have outstanding and the issues that they have on their plate, including birthright citizenship.
Yeah, we're going to talk about that one later on.
All of these things, right? So when you look at that, and then you look at the fact that they have actually taken 2 major Second Amendment cases this term, he probably feels like he's done right by us and that we should shut up and quit complaining.
As does the Trump administration and the Department of Justice and all that. Right. You know, you throw a few morsels to the 2A crowd. All right, you guys all go away for a while.
It's very annoying, actually. I mean, the Bill of Rights shouldn't be taken on a rationing basis.
Yeah. Here's another one I noticed. Now, we talked about this when Hamani was coming up, and that there was this other case out there. It was called Harris versus the United States. And it was just the most perfect vehicle that you could ever have on a cannabis case. Because, like, Harris volunteers for a church support group and occasionally uses cannabis to help sleep and happens to own a firearm. And there's no allegations of being part of a terrorist family or going to General Soleimani's funeral or any of that other stuff. Now, here's the cool thing. It was distributed for conference on January 9th. The last docket entry was actually made on December 23rd. It has not been heard from since, which I think is a good thing, because I think they're holding that for a GVR following Hamani. What do you two think about that?
Yeah, that's exactly what's happening. I mean, Erin Murphy was the counsel for Harris, and then she argued Hamani. So I think that's and our amicus brief also argued that they should drop Hamani and take Harris instead.
Yes, you did, and I appreciate that. It was a better vehicle to decide this issue.
At this point, they're one in the same. And actually, after what happened at oral argument, where they didn't even get into Hamani's other crimes, it just became a marijuana case. Hamani and Harris are basically the same case now.
Well, because if you take a look at just what the operative facts are, the issue presented to the court, they really are tantamount to each other. They're just so happens that Hamani's got all these other footnotes unrelated to the legal inquiry on that case.
Right. So at this point, assuming the court, as in oral arguments, disregards all the other stuff about Hamani and just treats it as a marijuana case, then yeah, I mean, this is it's a duplicate case, so it'd be weird if they didn't hold it for remand. Yeah.
Right. Okay, listen, for those of you tuning in right now, just so you know, we have been served another big steady dose of a nothing burger. That is, we have nothing on our group of 5 cases. So Duncan v. Bonta, Gators Customs Guns, Grant v. Higgins, NAGR versus Lamont, Viramontes v. Cook County. None of them have been listed on today's orders list, which means they're going to be rescheduled. Kostas, I don't know if you happen to see this. This is a little journey you and I have been on together. And that's the matter of Gardner v. Maryland, a case that I accidentally found, then you jumped on, then you got a bunch of other people one of the most compelling out-of-state concealed carry cases. The facts are perfect. That has finally been set for its first conference on April 17th.
Yep.
So that is a wonderful, wonderful thing. Hannah,
Yeah.
are you familiar with the facts on that one?
Somewhat. It's been a minute since I looked at that.
Well, so Miss Gardner is a lawful resident, I believe, of Virginia, lawfully concealed carry license holder and all that, goes to Maryland for business. She lives near the state line anyways. Goes into Maryland for business, is forced off the roadway by some, mad road rager who then is bum rushing her off on the side of the road, and she ultimately ends up displaying her firearm in self-defense. No allegation of assault, no allegation of unlawful pointing or anything like that. Merely displays it, saves the day for herself. When the cops show up, though, the only person to get arrested is Miss Gardner because she's in possession of a firearm in Maryland without the appropriate licensing credentials. That's the sole conviction that ends up out of that case. She ends up taking it all the way to the United States Supreme Court pro se. I find it on accident just taking a look at petitions. I mention it in a video for maybe 60 seconds. Just like, oh, this is an interesting one. I'm going to keep my eye on it. Kostas finds it. Kostas jumps into it, actually convinces SAF to throw in on an amicus brief. And from there, it kind of takes off like wildfire. Several of the 2A organizations end up jumping in on it. And then Miss Gardner ends up, I think, one of the big law firm. Is it Cooper and Kirk that jumped in on that?
Yeah.
They basically jump in and agree to take the case. So where she was a few months ago and where she sits today is radically different. Just because a little bit of attention got drawn to the case.
Yeah, she got the state AG to file a brief. A collection of senators filed a brief. We didn't get US DOJ, unfortunately, which is a bummer, but that was the one we really wanted. But that's okay. I mean, short of that, she got as much help as she could. Now, will the Supreme Court care? I know they requested a response, but is that just Justice Thomas spinning his wheels? I don't know. We'll have to see. It could end up just another denial and whatever, we tried. But but we're hopeful. Maybe something will happen on this one, given the amicus attention it got, and we'll see. Yeah.
So this would be more of a reciprocity case, right?
Yeah.
She has a permit. She has a Virginia permit. Yeah.
She has a Virginia permit. Exactly.
Yeah.
So, okay. The other thing I did, and I think there's a third one. This is the 18 to 20-year-old cases. Harris v. SAF. That's one of yours, Kostas. And then NRA v. Glass, which I don't know if NRA v. Glass is a challenge to the federal prohibition or the state of Florida's prohibition. And then there's a third case out there. But anyways, these are what we call the young adult cases.
Right.
They all went to conference, like in November, early December, and have never been heard from since. They're obviously waiting to get GVR'd. What is your guys' theory on what's going to happen with the 18, 19, and 20-year-old cases?
It's interesting because they didn't hold a bunch of other prohibitor cases, but they're holding the 18 to 20. So unless they're writing some sort of per curiam and that's the holdup, it looks like they're holding it for Hamani, but man, this seems like totally different than I know it's about who can have a firearm, but other than that, it seems like it's pretty far afield of what's in Hamani. So I guess it's possible they're using Hamani to say something more broad about who has the right to bear arms, but yeah.
But if that's the case, why did all the 922 G1 cases get their heads chopped off?
Maybe because of the rights restoration rule that's coming. That the
theoretically is coming, but they've been talking about that for months. Hannah, when did you and I start talking about that privately, right?
Yeah. So I have a different theory though on this.
Okay, let's hear it.
My theory is that they don't actually know what they're going to do on it yet, because this is a
theory is they're clueless.
Yes. So, but think about it. This one is the issue, the one perhaps I think maybe the only Second Amendment issue at the moment where there's a clear circuit split. That makes it hard to dismiss. Second, you have the Department of Justice weighing in and putting a thumb on the delay scale. Most of the amicus briefs, and the briefs and petition or replies, I think, filed by the United States, because they're party in one of them. They're not party in the Florida one, which incidentally is the one that Pam Bondi did fight back when she was Attorney General. So there's a lot of behind the scenes politicking, I think, going on this particular issue. The Department of Justice doesn't want them to take it, but they're not coming right out and saying it. They're saying it's not ripe, let's delay, et cetera, et cetera. And of course, we know the Roberts Court is very happy to take any excuse to delay an issue like this. So it's not easy to dismiss, but it's also not easy to take. And my theory is they just haven't decided yet what they're going to do with that hot potato.
Yeah.
But if that's the case, why not? Why isn't it on the relist cycle like Dunkin' and all the rest? Like, why isn't it just being relisted week after week? Like, they seem to have actively pulled it off the calendar. I don't know what determines. I've always wondered when they do like the 10 or 15
Right.
relists, why don't they just pull it off the calendar until they've decided and then put it back on? And
See, I think that's the bigger question. Why is our group of 5 still on the relist calendar?
maybe
Why
it's someone's writing a dissent, unfortunately. But if
Yeah,
that,
but they can hold it for that too. They know
yeah,
what.
I know. I know. I'd love to talk to a Supreme Court clerk to really understand
Yeah.
these. Like, why does it get relisted sometimes versus getting pulled off sometimes?
That
Like,
would be if you're a clerk at the United States Supreme
Yes.
Court.
Or
Number
former
one,
clerk,
probably
yeah.
shouldn't be
Help us out.
watching this right now. You should be working. But if you want to hop on Washington Gun Law, come on to a WGL AM. We would love to talk to you. You can let us in on all of the trade secrets. But it is an interesting thing because take a look at last year's gut-wrenching experience with Snope and the Ocean State case.
yeah.
The most excruciating thing in the world, only to get what we now call Snope. You know it's bad when it goes from a noun to a verb, okay? And but if they would have just pulled it, and then all of a sudden it pops up 2 months later, oh, look at this, it's set for conference again, and then we get the denial. That kind of would have made sense, but instead, where it's every single Friday, you're wondering, like, are you guys even doing anything other than adding its name to a piece of paper? Is it even being discussed?
And I wonder if it isn't, being discussed if they don't get to it. But more likely, I think with these hardware cases, they're just. I don't know what they're doing, because if we're getting snoped and somebody's writing a dissent again, and that's why. What is there to say? Like, if you're Justice Thomas, like, why wouldn't you just say, this is stupid, we should have granted this, see my dissent? Like,
you can cut and paste from all your other dissents. It's out there.
Yeah.
I'll tell you what we probably will get. We will get a third excuse for not taking them, and it will be different from the first 2. Remember the first one? It's not right. It's interlocutory. It's on the merits. And they've proven since then with other issues that they don't actually care about that.
Yeah.
Second one was, we need more percolation, like that's true, well, they've had more percolation. They even have a split in the offing. The third one's going to be, we're going to wait for a split. If they deny it, that's going to be the excuse this time.
Yeah, but I mean, it could be that, although, the only further development we've had since then that would be a bad sign is the DC Court of Appeals, which kind of came out of nowhere. If they're waiting on the Third Circuit, then that's a reason, I guess. But who knows when the Third Circuit's going to issue their ruling? And
Plus, we have no guarantee that the Third Circuit's going to rule the way
That's
we.
true.
They could disappoint us. Sure, they may.
And then we still have Miller percolating out there in the Ninth Circuit. That's just
gonna go. That's just gonna go the way of Duncan. It's the Ninth.
Yeah, but still.
Do you think that they're going to get another ruling on that in our lifetime, though, Kostas, out there?
I think they're probably going to wait till the end of this SCOTUS term, just in case there's more stuff in Wolford and Himani that they can use to screw us over.
Excellent.
And if there's anything in Wolford and Himani that helps us, they'll just ignore that.
So ignore it. There's your positive scouting report. Kostas Moros on the Ninth Circuit.
Yeah.
So, question then: do you think they'll apply that to the Third Circuit's also waiting on the same thing?
It's very possible. Yeah, some people have theorized that the Third Circuit, after having been GVR'd after Rahimi, annoyingly, because Rahimi didn't really change anything for their analysis. Maybe the Third Circuit's thinking, you know what, we don't want to do this again. We're just holding until June, and then we'll issue our ruling and pepper in some sites to Wolford. So they'll leave us alone and not GVR it again.
One of the other things that we think could be having some influence, of course, is what's happening out there in the District of Columbia with all the death, destruction, chaos, and mayhem that's going on there now that there's been a ruling striking down magazine bans. Hannah, I know with NAGR being a big national organization, how are you guys right now currently dealing with all of the chaos, death, and destruction that's happening in the District of Columbia?
I'll tell you what, Bill, it's an epic situation. I was just admiring the picture that you used.
Thank you, Grok. Thank you, Grok. You just tell it like, hey, make me a photo of DC in total destruction, and hey, there it is. Look at that. So, thanks, Elon. Okay, but as we know, the District of Columbia made all sorts of crazy requests, like grant en banc, don't even let Benson weigh in on it, but if you must, make him do it in a hurry. And the court basically said, no, this is going to take its normal course. Did any of you happen to see the amicus brief that came in from those 18 states?
Yeah.
Did you read it?
I listened to your video, which is the legal version of the Cliff Notes.
Yeah, well, I appreciate that. Kostas, you had a chance to read it?
Yeah, I read it.
Listen, pardon my language, Hannah. You know, I try not to use this kind of language in front of you because I try to be a gentleman, but
Appreciate it.
that brief is full of shit. I
mean, it's nothing we haven't seen before, though. It's the dangerous or unusual.
Yeah, but if you could take a highlight of every disingenuous argument that's ever been scattered amongst a whole bunch of different various memorandums on various cases and put it all into one highlight memorandum, it is that brief that was authored by those 18 states.
Yeah, especially because it had to be within 10 pages per the rules. So, like, it's like a real highlight reel or greatest hits of all.
Yeah,
like,
it is.
Speed run of all their crappy arguments. Unfortunately, those crappy arguments have been winning. So in the circuit we've seen from so far. So,
well, here's the thing. They definitely, you know, one of the arguments they were making is listen, if you strike a magazine ban down, it's just a matter of days before the streets are flooded with legal machine guns again. That's an argument. And as I read it, I was like, boy, they seem to be going back to that quite a bit. So I decided to do a word search, figure out how many times did they reference machine guns in a brief about a magazine ban. And the answer is 15. And you say it was a 10-page limit on that?
Wow.
Yeah, so it pops up 15 times in that memorandum.
Yeah, that's what they're trying to scare the court into granting en banc. You know, that's not surprising. And the court gave us some good initial signs by, you know, not letting DC have its way. Like, you know, they said, nope, you know, we're not going to stay the presidential status, and Benson will have the normal amount of time to reply. So that's a good sign, but we're not, you know, like I said on Twitter, we're not out of the woods yet, because that could just be them keeping up appearances when they're about to screw us over, you know. Yeah, you know, so we'll see what happens. But hopefully, I'm not expecting this, but I'm hoping this. Hopefully, the court sees through all this and sticks with the correct ruling and denies rehearing.
I'm trying not to be conspiracy-minded about this, because the reality is both the Supreme Court and the D.C. Court of Appeals are in the same city.
Yeah.
You know, it's a smallish community, then they all know each other. And if the Supreme Court had reason to not want Benson on their desks anytime soon. Again, I'm trying not to be conspiracy.
Yeah, no, but
it's possible.
But when we're reading the tea leaves, this is all we can do is try to connect dots and come up with theories on things.
Yeah.
So, well, guys, check this out. Unfortunately, between now and the end of the term, they are chock full of conferences. These are all the Fridays, and in a couple instances, they're Thursdays that are set for conference. So, I don't know how your guys' mornings are looking over the next couple of months, but we might end up having to do this. And of course, this is what I want you all to know, that I had Kostas come on one time because we were talking and it would be cool. And then all of a sudden I was like, oh, I'm going to get Hannah on. And then they've shown up for every single WGL AM since then. And I so much more enjoy having the two of you here and having this. So I want you to know that I'm very, very happy that you joined us. And Hannah, I want you to know that you are having a good hair day today, too, by the way. Your hair looks fantastic.
Thank you for noticing, Bill.
I'm a married man. I'm a married man, so I notice that kind of stuff.
You were trained well, I see.
Mrs. Gunlaw has trained me well. That's true. But no, you're having a good hair day, so enjoy it. So, all right. Listen, before we get rolling, there is a big case before the United States Supreme Court Wednesday, April 1st. It's Trump v. Barbara. Citizenship case. You guys had a chance to geek out on that issue? I know we're getting outside the 2A, but it's a fascinating little argument they got coming up there.
No, but
I was at a Federalist Society West conference on Saturday, Western Chapters Conference, and there was actually a debate there between my friend Ilan Warman, who's written a lot of the Birthright citizenship scholarship against the expansive prevailing view of birthright citizenship. So he debated John Yoo. And for those of you who don't know, John Yoo is the guy who wrote the torture memos. but so he's a Berkeley law professor, most infamous for the torture memos during the Bush administration. But despite being like this fierce proponent of the unitary executive, very expansive view of presidential power, he actually thinks that birthright citizenship is expansive. Like he thinks, nope, it's if you're born on U.S. soil, unless you're like the kid of a diplomat or something, like you are a citizen, and that's what originalism tells us. So, well, it was an interesting. I thought Elon had the better points overall, but I also think that. And this is me not really understanding this field. I haven't studied it or anything, but I just feel like there's no way Chief Justice Roberts is going to disturb birthright citizenship. It doesn't matter that Werman and Amy Swear and others probably have the better arguments. It doesn't matter. They're not, in my opinion, they're not going to disturb this. Most likely, they won't even reach the merits. What I predict they'll do is they'll find a way to say the executive order wasn't okay. Like they'll say, yeah,
like they did with the tariffs thing.
Yeah.
So I did a video about it because I viewed it as an opportunity to take a complicated legal issue and use some simple English and try to get everybody to understand it. And it really comes down to a conflict in like the first sentence of the 14th Amendment, where it starts off, all people born in the United States shall be citizens when they are subject to the jurisdiction thereof. And so the argument is one side saying born on American soil, that's good enough. And there's a litany of case law that says that. The other side saying, but you got to be subject to the jurisdiction of, and when you enter this country illegally, you are not subject to the jurisdiction thereof. The other interesting argument is that when you take a look at when we ratified the 14th Amendment and why we ratified the 14th Amendment, let there be no doubt it was absolutely the right thing to do, because we were talking about descendants of people who had been brought to this country against their will. Okay, so it's now, but what we have today is descendants of people who came to this country against our nation's will.
Well, but against their own will too, many of them.
In some instances, yeah. But, and I agree with Kostas. I think that the 14th Amendment deserves a serious reexamination. It does. There's a method to do that, and it's very difficult to change the Constitution, and our founding fathers did that on purpose. But what I really think the issue is this. Can the President of the United States change the application of the constitutional amendment through an executive order?
Isn't that a hard no?
I mean, I don't care who the president is. To me, that is a big hard no. And for those of you who, again, the real Trump loyalist who thinks he can do no wrong, I'm not going to debate you on that. But I just want you to imagine a President Gavin Newsom someday and think about what constitutional right he might want to do away with an executive order.
Yeah.
Right?
Newsom declares that the Second Amendment is only about a militia.
That's exactly what it would be. That's exactly what he would do.
To steelman it for Trump, I guess the counter argument would be, well, he's not really going against a court ruling like Newsom would be if he declared that. He's, clarifying the government's position, and they can argue it out. You're still probably right, though. I don't think it's going to.
Yeah, well, but if you take a look at that Wong Kim Ark case from way back in the day, Trump's order arguably does go against the Supreme Court.
That's true that Trump goes. So Alon Werman, who I heard argue, and other people don't go as far as the Trump EO did. They just say, yeah, Wong Kim Ark's consistent with our view because Wong Kim Ark's parents were here not against the consent of the country, whereas illegal immigrants are here, so yeah, we'll see what happens. I don't, one of the questions I wish I got to ask John Yoo, because they had a very short Q&A session, so I didn't get my question, is, he was up there arguing, subject to the jurisdiction thereof at the time was only applied to diplomats, invaders, and Indians, and that's it. Everybody. So I wanted to ask him, okay, but why wouldn't they just list those three things out if those are the only exceptions they meant by that phrase? And also, doesn't Rahimi in the Second Amendment space tell us that the law is not trapped in amber? So why should subject to the jurisdiction thereof be limited to the analogs that they cited at the time? None of this matters, though. It's an interesting question, but the Supreme Court,
it is. It's a fascinating issue.
Yeah. So I haven't studied the legal arguments here. From a layman's
That's because you work for NAGR, so you don't have to worry about birthright. Crap to worry about.
But from a layman's standpoint, isn't there an argument to be made that subject to the jurisdiction thereof actually does apply the minute you cross the border? Because at any point you could be arrested and deported, and that would be a proper use of the jurisdiction.
Yeah, what I think Werman would say to that is two things. First of all, a lot of the debates at the time in the Senate, and I know textualism says we don't necessarily look at anything but the text and what was passed. But the debates at the time, they would say things like subject to the complete jurisdiction, subject to the full jurisdiction. They weren't just talking about people who are, for example, if a soldier, an invader, or an Indian, or even a diplomat commits a crime here, they could, in theory, be arrested and charged with that crime, even though they're not subject to the jurisdiction thereof. And that just tells us, they're not subject to the complete jurisdiction.
Okay.
So that's how they would respond to that. It's not that you can't be arrested and prosecuted for a crime, but you're still not fully subject to this. But to your point, though, is basically what the birthright citizenship people, the expansive view people argue. Like, yeah, other than these very narrow exceptions, it is anybody who's here is subject to our jurisdiction. So that's why, birthright citizenship is what it is today. And that's probably the view. If they do reach the merits, I expect that's the view that will prevail, just because it would be too disruptive. And John Roberts hates disruption.
He does.
Yeah.
Yeah. Chief Justice who doesn't want to do Chief Justice things.
Yeah.
All right. So, hey, just for those of you tuning in, first of all, for all of you tuning in, for those of you catching it on replay, thank you very much. We have a big nothing burger as it relates to our group of 5 cases. We've been solving the rest of the world's problems this morning. Don't know if we're going to accomplish all of our goals, but we do it. But I do want to remind everyone that our friends to the north up in Canada they're having a bad year. They're having a really bad year. Both their hockey teams got their asses kicked by the United States. But then this gun confiscation thing has been an absolute, complete, unadulterated disaster. And the press conferences only make it more disastrous, although they do give you lots of material. So I'm going to be with Ian Runkle tomorrow evening, 6 o'clock on the West Coast, 9 o'clock on the East Coast. Ian, really fantastic attorney up there in Canada. We're going to be talking about everything related to Canada's voluntary gun buyback program. It's voluntary until the end of this month, and then at that point it's compulsory, so I don't really think it's voluntary. But anyways, it is a complete unadulterated disaster, and a lot of people are sitting there going, why are you even worried about what's going on in Canada? Well, there are several states in this country who would gladly do what Canada is doing right now if given the opportunity. So tune in on that. Have either of you been paying any attention to what's going on up there?
A little bit. So we actually had last fall we had a conference, and we actually brought down some of the people from the gun rights group up there in Canada.
Yeah.
Geek out over political and legal tactics and whatnot. It's a frightening thing because, there's a sense for an American that you're watching a dystopian movie, knowing in the back of your head that if you don't do something, this could be you, probably a lot sooner than any of us would like to think. And it's literally our next door neighbor, a neighbor who has enjoyed the same inheritance from the UK that we did, that of, common law freedom and due process and everything straight from Magna Carta. So if it could happen to England, if it could happen to Canada, it could happen to us.
That's right.
Yeah, I joke. I like to joke that I, litigated in the Ninth Circuit for years. So I was playing on hard mode, but I guess Ian has that on me. He's playing on insane mode if he's in Canada.
One time the first time I met Ian in person, we were down in Uvalde, Texas. We were down there for a gun deeds, and how it is when two geeks get together, you start geeking out, right? And he starts telling me about a case. I believe it was a case that he had defended where the individual had been acquitted of murder. Awesome. And then Canada appealed the verdict. And I about fell out of my chair right then. I was like, I'm sorry. Did you just say that Canada appealed a not guilty verdict? And he's like, yeah. And they won on appeal. And I'm like, oh my God, because for those of you who don't know, there's a reason LA County didn't appeal the O.J. Simpson verdict, okay? It's because they couldn't. So yeah. Hannah's jaw saying that you didn't know they could do. Yeah, Yeah, they do things a little different up there, Hannah.
Wow. I mean,
Yeah.
there's a lot of things that are insane about Canada, but goodness.
I like
All
the
right.
poutine though. Good poutine. I like the cheese curds.
Yeah, they got a few things going for them.
Yeah.
Hey, Vancouver, British Columbia, which is only 3 hours north here of Seattle, is a fantastic city. It really is. It's a pretty good town. So, all right, closing thoughts before I let you all go. Hannah, you have any closing thoughts you want to, words of wisdom you want to impart to our audience?
I'm just really, really glad that if they weren't going to say yes, that they didn't at least say no. Again, because the minute they do that, it's open season on the Second Amendment in a way, even more so for these deep blue states. It's bad enough what we see them doing in Rhode Island and Virginia and everywhere else. That's going to get 10 times worse if they pull another Snope, if they say no to the group of 5. And you can't blame the thought process of anybody in those states for doing that. So I'm hoping that the Supreme Court is at least thinking about that and taking that into consideration, and that if they're not going to take it, they're going to delay that as long as possible, at least till after the legislative sessions are over for the states.
Kostas, any final
Yeah, I echo a lot of that. I don't really have any original thoughts other than I hope they tell us good news soon. That's all what we're ultimately waiting for. So
You're probably going to have to call 911, Bill, for both of us. If if we get good news one of these.
Well,
will be weird.
Good news. My biggest concern is Duncan's gets denied, and then we got Kostas on like suicide watch for about 48 hours.
I'm gonna run and go hide my magazines, right away.
Yeah, exactly. Well, here's my words of wisdom to the United States Supreme Court. Listen, if you guys are going to take another month or so to make up your freaking mind on this, can you do us all a favor and not just keep rescheduling this every freaking Friday? It'd be really nice later today to check the docket to be like, hey, it got relisted for conference, but it's not for another month.
Yeah.
Please and thank
I have a feeling that if we're back again next Monday, and the problem, and everyone's like, oh, it's just going to be a nothing burger. It's just going to be a nothing burger. Yeah, you're probably right. But one of these Mondays, it's not going to be a nothing burger.
Yeah.
Because one of these Mondays, we are getting an answer.
And it's not necessarily the last one either, because remember, we got snoped on like early June. There were still a few more weeks left.
Oh, yeah.
So
no, that was a gut-wrenching experience, which I unfortunately didn't have you two going along on the ride with me. So that was a solo excruciating experience on that one.
We can't just assume that, it won't happen until the very last orders list, because that would otherwise be safe. But then, who knows, maybe some late April date,
Right.
we'll have all of them denied or one of them granted, or, so we just have to play the game and keep checking, and hopefully something happens sooner or later.
The minute we don't do one of these, though, that will be the one.
Yeah, that's exactly what's going to happen. We're like, let's just blow it off. It's not going to happen. And I'll be checking Twitter at like 6:30 in the morning. It's like, something got accepted. Damn it, really, now we're scrambling around trying to do it. Well, listen, I do want to thank both of you for getting up, Kostas. I know you and I, it's really early in the morning, but thanks so much for being here. Hannah, congratulations on the fantastic hair day you were having.
Thank you.
You were going to kill it. You're going to kill it today, girl. I want you all
you're making it sound like she usually comes here with just terrible hair.
No. Hannah has beautiful hair. I'm not going to lie. But occasionally, you have a day where you just look at a person's hair. I mean, look at it right now, right? And you're just like, dang, you got it going on today. And that's what.
Do that, as a woman, you're like, good things are going to happen today.
That's right. That's right. The power of the hair. All right. You two are awesome. And for all of you who tuned in live, thank you very much. Go have a great work week. For those of you who are checking it out on replay, I hope it's during your lunch hour so that you're at least being mildly productive at work. We may be back next Monday. Who knows? It's going to depend on when all of these cases get relisted. I know for certain we're going to at least do something after that April 17th conference because, well, I'm interested to see what happens with Gardner. I just think
if any of the Supreme Court clerks if the Supreme Court clerks are listening to this, could you just schedule the hardware cases for April 17th?
Just throw it all on April 17th. That would give us a killer April 20th, 420.
That they better release Hamani on 420.
Oh man, I got it. Be, I think I'm on a damn airplane on April 20th too.
That's going to be the day then if you can't make it.
Yeah, that's going to be the day. I'm going to have to check that. We'll figure it out. We'll figure it out. All right, guys, thanks a million for being here. For all of you who tuned in, thank you very much. For all of you going to watch it on replay, thank you very much. Have a great work week. Keep fighting.